Here is a detailed and exam-oriented explanation of the provisions relating to protection of professional communications under the Indian Evidence Act, 1872. Protection of professional communications, Sections 126 to 129, Indian Evidence Act, 1872. Meaning: professional communication refers to confidential communications exchanged between a legal professional, advocate, vakil, attorney, pleader, and their client during the course of their professional relationship. These communications are protected from disclosure in court to preserve client confidentiality and ensure effective legal representation. Relevant provisions, Sections 126 to 129. Section 126, Professional Communications not to be disclosed. No barrister, attorney, pleader, or vakil shall be permitted to disclose: 1. Any communication made to him by his client during the course of his employment. 2. The contents or condition of any document with which he has become acquainted during such employment. 3. Any advice given by him to the client. Conditions for protection. Condition, explanation. Professional employment. The legal professional must be formally engaged by the client. During the course of employment, the communication must be made during and for the purpose of legal advice or action. Confidential in nature. The communication must be intended to remain private and confidential. Exceptions to Section 126. Disclosure is permitted if 1. The communication was made in furtherance of any illegal purpose, or 2. The lawyer becomes aware of a crime or fraud committed since the start of the engagement. Example: if a client consults a lawyer to plan a forgery, this communication is not protected. Section 127, Extension to interpreters and assistants. The protection under Section 126 extends to interpreters, clerks, servants of the legal professional. They also cannot disclose any protected communication they came across in the course of professional duty. Section 128, Privilege may be waived by client. The privilege belongs to the client, not the lawyer. A lawyer cannot disclose anything without the client's express or implied consent. Section 129, No compulsion on client to disclose. A client cannot be compelled to disclose any confidential communication with his legal advisor unless the client voluntarily offers himself as a witness and he refers to such communication in his testimony. Key case laws. 1. M.S. Hoshiar Singh v's Emperor, AR 1937, all 62. Advocate cannot disclose client communication even under oath. 2. Kochuni v. State of Madras, AR 1959, SC 725. Protection applies to honest advice given in legal matters, even if it leads to litigation. 3. Siddhartha Vashisht v. State Manu Sharma case, 2010, 6 SCC 1. Privilege does not extend to communications made for illegal or fraudulent purposes. Summary table, section provision, key idea. 126, no disclosure by legal professionals, protects confidential legal communication. 127, applies to interpreters, clerks, servants, extends the same protection. 128, client can waive privilege, right lies only with the client not compellable to disclose unless voluntarily testifying on it. Conclusion. The protection of professional communication is vital to maintain the sanctity of the lawyer-client relationship. It ensures free and frank discussion between a client and their lawyer. However, this protection is not absolute. It does not cover communications made for illegal acts or fraud. Would you like this rewritten as